As noted in the published agenda, today we will be hearing presentations from the Saugeen Ojibwe Nations and the historic Saugeen Métis. I would like to acknowledge that we also have members of the Métis Nation of Ontario with us in the hearing room. Welcome. We will also be discussing the panel's questions arising from the new information presented on September 10th, 2014. The first presentation of this morning is by the Saugeen Ojibwe Nations, which is PMD 14-P1.22. Chief Root, welcome. Mr. Monham, Mr. Kagi, the floor is yours.
Thank you and good morning, Madam Chair and members of the panel. My name is Alex Monham. I'm legal counsel for the Saugeen Ojibwe Nations, known as SON or SON. I'm joined today by Mr. Randall Kagi, as you know, former chief of the Saugeen First Nation, as well as current chief, Chief Root. I'd like to also acknowledge the members of both communities in the audience today, as well as leadership. Mr. Kagi is now representing SON as counsel and as the lead for the SON OPG process to determine SON community support for the to address legacy issues. He is here to answer questions you may have on that process or questions more broadly on SON's understanding of its rights and interests in the territory. We also have on the phone this morning Messrs. John Greaves, Dan Musati, and Stuart Bland. These are technical experts who have been assisting SON in its review of the application and who have contributed to our analyses of the IEG report as well as other sections of our July 21 submissions. I will not read out their qualifications, but their bios are contained in an appendix to our August 2013 submissions. Also on the phone is Dr. Steve Crawford, who we met last year, and Dr. Neil Rooney, both of whom are professors at the University of Guelph and have a long-standing technical advisors to SON and can answer questions you may have respecting aquatics or environmental assessment matters. Dr. Crawford is actually in Bay Doré right now collecting samples as part of a SON-sponsored research program, so he'll be calling from the water. I intend to make relatively brief submissions on OPG's revised residual adverse effects analysis, the WIP incidents, the updated geoscientific verification plan, and the plan for DGR expansion to accommodate decommissioning wastes. I will discuss the alternative means risk assessment and the IEG report in more detail and explain the position of SON that the decisions made here in respect of this project will inevitably influence the development and review of subsequent projects within SON territory, including possibly a future DGR for spent fuel. And for this reason, we must be very cautious about how we characterize and understand some of the issues that have been raised in these proceedings. I will begin with the significance of the residual adverse effects. In our written submissions of July 21, we indicate our concern that the renewed analysis provided by OPG in response to information request EIS 12-510 fails to adequately address the key concerns identified by Dr. Dunker in his analysis of the original work. In particular, the renewed analysis still relies too heavily on expert judgment and fails to present data or discussion in support of its conclusions. Further, we note that OPG's analysis relies too heavily on generalized assumptions and provides insufficient consideration and study of actual local conditions. An example of this is its determination of the 20 to 30% threshold for significance of effects on woodlands. There appears to be little account taken of local factors that could indicate how a particular patch of mixed wood in this area could contribute to the plant population sustainability and productivity. There remains a persistent and erroneous assumption about the quality of McPherson Bay, and that is that it is a site of poor quality habitat. To the contrary, there is evidence that it is actually quite good habitat for lake whitefish, a species of central cultural and economic importance to SON. We have made submissions on this in the past, and Drs. Crawford and Rooney can address this issue further if necessary. The potential significance of interaction between the DGR project and McPherson Bay is further muddied by uncertainty respecting the ultimate design and performance of the stormwater management pond. We heard clarified on Monday and again yesterday that CNSC has asked OPG to provide an assessment on the necessity of resizing the pond to account for a revised PMP event and to prevent untreated releases into the lake. We will wait for more clarity on this matter. The last point to make here is on the assessment of significance in respect to adverse effects on Aboriginal interests. As we say in our July 21 submissions, OPG's analysis has a central problem. It does not take into account the Aboriginal perspective in its analysis. In its response, OPG acknowledges that, quote, there are no absolute effects thresholds to use when evaluating effects that diminish the quality of or value of activities undertaken by Aboriginal peoples at Aboriginal heritage resources. OPG then relies on professional judgment of the experts who performed the assessment. The significance of impacts here can only be determined by the Aboriginal people themselves. To understand this any other way, for example, to consider a significance effect to the resource that Aboriginal people have an interest in, rather than consider the significance to the Aboriginal people of the diminished resource, is to do nothing more than repeat the standard analysis without any regard to the Aboriginal interests or concerns. As Mr. Coggy stated a year ago, and I quote, "If our people come to believe that it is no longer right to consume plants, fish, or animals for deep or spiritual reasons, this cannot be mitigated by demonstrating that there are no new radiological effects." He went on to give one example, and I quote again, "Say, for example, we have 4 medicines that we utilize. Sweetgrass, for example. We use that. It's one of our sacred medicines. We use that for many different things, in our prayers, in our ceremonies. What does it mean if somehow there's an apprehension or a concern that sweetgrass is somehow less pure? And what does it mean in the context of utilizing it for those purposes, for those spiritual purposes? I don't know." Significance of impacts on Aboriginal interests is not an analysis or assessment that OPG can be expected to carry out on its own. And it is not something easily amenable simply to further and better study. Rather, these kinds of adverse effects are real and can only be addressed through a full engagement with those who are affected. It is the users of the land, animals, and plants, and those whose spiritual and cultural identity is bound up with that land that will have to come to terms with the changes the project could bring. And ultimately, they will have to be the ones who will choose to accept or tolerate those changes. I will turn now to EIS 13.5.15 and the analysis of the WIP incident. The incidents at the WIP facility are serious and troubling and have the potential to undermine public confidence in the DGR concept generally. We should not try to diminish the significance of this event or these events. Nobody saw this coming a year ago. Nobody came forward to explain the various problems of diminished safety culture at the DOE or problems with contracting out packaging of nuclear wastes. And nobody predicted that these were all accidents waiting to happen. The fact is, everyone understood WIP as a well-designed project being carried out by a responsible proponent and overseen by a strong regulator. Of course, we must all treat this as a learning opportunity, but we submit that the real lessons from WIP are not yet known, and this creates a real timing challenge for us all. The Phase 2 report is to identify the root cause of the radiological release event. From what we have understood so far, this may have something to do with problems related to the packaging of waste. If this is so, this should cause us to re-examine and refocus on the importance of the waste acceptance criteria and the waste inventory verification plan. It will also force us to consider the management chain of packaging wastes. But this is all speculation, because we do not yet have the Phase 2 report in hand. We need to understand clearly what the process will be for OPG and CNSC to review and analyze that report, and review and revise as necessary the relevant aspects of the DGR project proposal. And we also need to understand what the opportunities for public input into that process will be and how it will be reviewed. The other lesson from the WIP events relates to the degraded safety culture. With respect, this is not a cause, this is a symptom. For our purposes, it is necessary to understand what conditions will give rise to a deterioration of a safety culture. We have no reason to doubt that OPG has a good and reliable safety culture. But over time, companies evolve. In the future, OPG could have new shareholders. It could fundamentally restructure its business. It could divest some of its assets, including the DGR. CNSC too can evolve. The DGR project must continue to operate safely for many decades, and will need to be carefully decommissioned if the assumptions of the safety case are to remain valid. We now understand that a key component of this will be an intact safety culture, one that must continue to be in place regardless of the underlying changes in the corporation or the regulation scheme. It is still not clear to us which of the key aspects of safety culture are required under regulation and which are voluntary. I understood CNSC as stating that it had not yet conducted an analysis to determine whether the incidents at WIP were due to a failure to comply with applicable legislation, regulation, and guidance, whether there was a gap in that regulation, or there was a failure to enforce that regulation. We believe this is a necessary exercise. There seems to be significant overlap in the guidance documents that DOE and the CNSC rely on. And we suspect that more broadly, there is also significant commonality between the regulation that governs the nuclear industries in both the US and Canada. If the WIP incident is any way connected to a failure of regulatory oversight, this is a more serious and fundamental problem. For this reason, it is critical that we understand exactly what was the cause of the degraded safety culture at the WIP facility and what steps are required so that we can prevent that from occurring here. Turn now to the geoscientific verification plan. You have our more detailed comments on the revised plan in our July 21 submissions. We do not have our geologists on the phone today, but as we're going to address this subject tomorrow, if it will be helpful, we can have them available. But overall, we understand the revised plan to be an improved form of the 2011 version, but still in need of detail and specificity. In particular, SON would benefit from a clearer discussion and articulation of hold points and triggers for further study and review of modeling and safety case assumptions. We presume this will be addressed in greater detail tomorrow, and we'll hold off with our more specific questions until then. A related matter was raised by Dr. Dussault in his testimony last week, the concept of adaptive engineering. In the worst case, to SON, this sounds like a euphemism for engineering around problems. When I asked OPG whether adaptive engineering was part of their development philosophy, Ms. Swamy thankfully confirmed that they are relying on their existing design. However, we did start to get into a discussion of what was referred to as scenarios. Mr. Derek Wilson started to discuss that OPG had anticipated a number of scenarios that might be encountered during construction and their strategies for dealing with those scenarios. We hope that this subject will be addressed in more detail tomorrow. It is important for us to have a better understanding of these scenarios, how they align with the geoscientific verification plan, whether any of those correspond to defined holding points, and how such situations will be identified, studied, and actioned, including how that plan will be reviewed. On the decommissioning waste expansion plan. As we have said in our written submissions, SON now believes that this project is better described as a phased-in repository for 400,000 cubic meters of operational refurbishment and decommissioning low and intermediate level nuclear waste. How this repository will ultimately be used and developed, however, is still an open question. The exact size of the repository and the exact waste streams that it will house will be determined at a later date and in response to future OPG business decisions. We do understand that material changes to what is proposed in this application will be subject to further regulatory review. However, as we have said before, we remain unclear on which changes will trigger what regulatory review. We have asked before for an analysis that would clearly set out which future project evolution scenarios would trigger regulatory processes and the precise nature of those processes, including the scope and mandate of the review and the opportunities for public participation. By future evolution scenarios, we mean, for instance, proposed changes to the waste acceptance criteria, including changes to the ratio of low and intermediate level wastes, or inclusion of new waste streams. It would also include changes to the physical design of the repository, including incremental expansions, as well as expansion that amounts to a doubling of capacity. Our concern is to ensure that we in the panel are not being asked to sign a blank check to give OPG or a successor corporation and the CNSC the authority to develop and review the DGR without environmental review and oversight and public input. But this alone is not sufficient. SON has an abiding concern expressed many times in these proceedings that we do not yet know the full potential for this site as a nuclear waste management site. From yesterday's discussion, we are not satisfied that we have enough information to draw hard limits for potential expansion of the site for increased and diverse nuclear waste disposal, or that we fully understand what the drivers for such expansion will be. This review is our last opportunity to consider the big picture view of the future of this site as a site for permanent nuclear waste disposal. This is the only opportunity we will have to perform a strategic level planning analysis on this question, which is the core function of an environmental assessment. As we've said in the past, future regulatory processes, including a full environmental assessment, will ask a narrower set of questions or may have more limited opportunity for public engagement and will be carried out in the context of an existing and operating DGR on site, or at a minimum in the context of a partially constructed DGR that represents a $1 billion investment on an already disturbed site. SON submits that we should have a much clearer understanding of what the future evolution scenarios for the DGR project are now, before we can make a good and informed decision whether to go down this road. I will now turn to the alternative means risk assessment and the question of community acceptance. SON has already addressed these two issues in some detail, both orally and in written submissions throughout these proceedings. For SON, these represent very important aspects of the current application. First, the SON leadership and its communities care enormously that this project should represent the best and safest way for dealing with what they perceive to be a nuclear waste problem in their territory. And to come to this conclusion, they need assurance that all options have been credibly explored. But also, this project represents a significant new nuclear project developed in the SON territory and will be viewed as a precedent for the development of future nuclear projects in the territory, including either an expanded DGR for decommissioning wastes, which appears inevitable, and potentially a future expansion or new DGR for spent nuclear fuel. Finally, this project has been developed on the basis of community acceptance, and more specifically, a concept of a willing host community. And the community acceptance language has persisted throughout these proceedings, including in the panel's most recent request asking OPG to produce an alternative means risk analysis, which includes analysis of community acceptance. Again, this has potential to become precedent-setting. To my knowledge, this will be the first time a Canadian review panel will consider the concept of willing host community and community acceptance more broadly in the context of a proposed new nuclear project. And as the panel is aware, this is a central concept within the adaptive phase management approach that will lead to Canada's spent nuclear fuel DGR. It is for these reasons that I will address the issue of alternative means and community acceptance in more detail. With respect to alternatives, it has been SON's position that there has not been sufficient material available to the public and SON with respect to viable alternatives to this project for the management of low and intermediate level radioactive wastes. The panel in EIS 12-513 required a renewed and updated analysis of the relative risks of siting alternatives, and it set out 4 options to be analyzed, including enhanced surface storage at the Western Waste Management Facility and a granitic DGR in the Canadian Shield. This analysis was to be carried out by an independent risk assessment experts. SON's original position on this matter is unchanged. We do not believe the report of the independent expert group has added any new substantive data or analysis to the alternative means assessment for this project. In our view, the IEG report provides primarily a new way of visualizing the data and analysis that was already on the record in these proceedings. The report of the IEG does offer a new qualitative determination of relative risk. However, while aspects of its methodology were clearly described, crucially, others were missing. For instance, we have no good understanding of how the expert group assessed each of the risk pathways for the 4 options, how those were synthesized, and how that was translated into the very precise placement of icons. Members of the IEG described the process of workshopping and coming to a consensus on placement, but very little detail was given that would allow a third party to assess the precise methodology or process used in the workshop. We have no ability to judge the methodology employed more generally, because it appears to have been developed specifically for this process, and there is no literature we can refer back to assess its validity, accuracy, or utility. The IEG acknowledges that given the time constraints and the size of the group, it did not consider other methodologies or approaches that might have led to more objective results. The IEG acknowledges that its results are not reproducible in the sense that another group of experts applying the same process described by the IEG with the same inputs could come to a different result or different results. Given all of this, we find it difficult to understand how this new qualitative analysis of relative risk of alternatives contributes materially to our understanding of the actual relative risk of even the 4 options they considered. A more fundamental deficiency in the IEG's work is that it did not consider what SON believes to be a representative set of the full range of options for the long-term management of low and intermediate level nuclear wastes. First, the IEG did not consider, under the case of enhanced surface storage, the possibility of segregation of the longest living ILW for eventual disposal with used fuel. They did not believe it was within their remit to do so. In testimony, Dr. Leese did clarify that his group does acknowledge this approach being employed in both Spain and France, but did not feel it was an option within the Canadian context. For reasons we have previously explained, SON does not agree with this. We have a siting process for a used fuel repository well underway in Canada. And OPG, we understand, is already considering or planning to segregate some long-lived intermediate level wastes for disposal in that repository. We believe that the failure to consider a more refined treatment of the longest lived intermediate level wastes constitutes a significant omission from our considerations here. Another significant omission in the IEG's work is its failure to consider a credible granitic DGR. We have had ample discussion of this already, and we set out our position fully in our July 21 submissions. Our position has not changed based on any of the testimony of the IEG that we've heard during these most recent hearings. However, we do wish to emphasize that not only has the IEG report, to our minds, failed to consider a credible granitic DGR, it also provides a questionable analysis and commentary which could be understood as having applicability to future DGR projects, including a spent fuel DGR. This is a concern that was also expressed by the CNSC in its review and presentation. It identified in the IEG report misleading statements about the characteristics of granite of the Canadian Shield and their implications for a comparison of a Canadian Shield site with a Bruce DGR site. CNSC concludes that, and I'll quote here from the presentation, out-of-context statements about rock types could lead to misconceptions about the suitability requirements for this or other deep geological repository projects. We believe the testimony of the IEG in these proceedings has exacerbated this problem. In testimony, Dr. Dussault reiterated and expanded on a number of conclusions about the general characteristics of granitic formations that could influence their perceived suitability for DGRs, including their fracturing tendencies, unpredictability of such fracturing, and the increased difficulty of characterizing such sites relative to those in sedimentary rock formations. We are not experts in these matters, and Dr. Dussault's comments may or may not be accurate. The problem is that his conclusions have not been explained or justified, and they have not been tested, and they have not been presented in the context of a full, fair, and balanced exploration of these matters. Still, the work of the IEG, including the statements of Dr. Dussault and their overall assessments of relative risks of granitic and sedimentary DGRs, is now on the record as the conclusions of an independent expert group. It is obvious that this has the potential to influence or support future decisions with respect to preferred rock types for DGRs. And of course, it has been one of SON's consistent concerns that these proceedings and its outcomes could influence the ongoing process for identifying a site for a spent fuel DGR. I'd like to move on now to the question of community acceptance. As is clear from the record, OPG has moved forward with its application on the basis of having community support. In part, this support is evidenced by an agreement with the municipality of Kincardine. OPG subsequently made a commitment to SON not to proceed with construction until the SON communities are supportive of the project. OPG and SON are now developing a process whereby there can be a determination of SON community support, as well as an understanding and building of conditions that could lead to community support, including the resolution of broader legacy issues. SON and OPG are now finalizing a framework agreement that will structure their engagement and implement that commitment. And SON has already done significant internal work to build a process for full, culturally based engagement of its communities and the realization of a true community-driven process. With respect to this project, it is the position of SON that OPG has taken positive and appropriate steps in regard to seeking and determining SON community support for the DGR project. By its commitment to SON and through the full implementation of that commitment, OPG is proceeding with SON in a way that fully satisfies our understanding of the requirements of community acceptance with respect to projects like the DGR and those articulated in the adaptive phase management process. In our submissions, we have indicated that the SON-OPG commitment ought to be recognized and reflected within this environmental assessment and subsequent regulatory processes. In keeping with our mutual commitments, we have been working with OPG in order to provide the panel with a common position on how this could be accomplished. And we will make sure that this is done in final submissions. We will also endeavor to remain in contact with CNSC to ensure that what we propose is sound. I wish now to turn to my final point, and that is to address the process for determining community acceptance, not for this project, but rather more generally. As I stated earlier, this will have ramifications for the development of other major projects within the SON territory, including future DGRs or other significant nuclear developments. First, as we stated in our August 2013 submissions, SON does not accept that a municipality or municipalities could be host communities for major nuclear projects at the Bruce nuclear site or otherwise within SON territory while SON is excluded. It is unthinkable to SON and its leadership, and I would submit inconsistent with law, for a municipal corporation to make decisions on behalf of or in place of SON that could materially impact SON's rights and interests. It is SON's fundamental position that it must be considered a host for any major nuclear project within its territory. Second, community acceptance is not a determination that can be made unilaterally by a proponent, regulator, government, or reviewing body. Further, it cannot be determined based on an assessment of risk perception, risk acceptability, or any other proxy. In our written submissions of July 21, we set out in some detail our objection to the use of risk perception as a proxy for community acceptance. And I will not repeat that now. We agree to an extent with the conclusions of the IEG respecting community acceptance, namely its conclusion that it did not have sufficient data to answer any question of community acceptance of the various options it considered, and it did not have enough data to draw credible conclusions about the more limited questions of relative risk acceptability or perception relating to the four options. However, from SON's perspective, it will never be possible to draw conclusions about its community acceptance based on assessments of risk perception or risk acceptability. As we note in our July 21 submissions, the IEG report echoes many of the same ideas that SON has communicated to you, especially in last year's hearings, about how its communities might perceive risk from this or similar projects, and how that might impact SON community members' perceptions about their harvesting, spirituality, and their cultural identity on the land, and I've repeated some of that here again today. These perceptions of risk cannot be dismissed, and they're not easily addressed. We heard good suggestions from the IEG on how risk can be better understood, what steps can be taken to increase trust and confidence, which might act to mitigate high perceived risks. But we have also heard, and we have seen from recent events, that risk cannot be reduced to zero, and at the end of the day, those subjected to the risks, however small or large they might be, must be willing to accept those risks, or at least willing to tolerate those risks. It does present a real problem if the evidence before this panel or its decision is capable of being understood as supporting the notion that SON community acceptance for a future DGR project can be ascertained solely through a contractual agreement with a municipality or through mere predictions of community acceptance based on risk or perceived risk. SON states that its acceptance can only be determined through a clear expression of acceptance or support from the SON communities themselves, and after a deep engagement process between SON, the proponent, and the Crown. SON believes that a process like the one committed to by OPG with respect to this DGR project is a full expression of this approach and what is envisioned and required by concepts like willing host community and volunteerism under the adaptive phase management process, as well as what is required under the common law of Aboriginal and treaty rights and international law and declaration. Those are my submissions. Thank you.
Thank you, Mr. Monham.